Good evening everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. This is our 70th lecture series. Before going to the topic, it is our regular practice that we recite preamble of the Constitution of India as our daily prayer. So I request each one of you to recite preamble along with me. We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact and give to ourselves this Constitution. We are going to deal with Dr. KAVITA KAMBOJ versus High Court of Punjab and Haryana and others. It is reported in 2024 volume 7 Supreme Court cases, page number 103 in detail. So in this lecture, I will be taking you to the relevant portions of the judgment. Therefore, that will be easy for you to write your Advocate on Record examination. This case came up before three honorable judges. Honorable Justice Dr. D.V. Chandrachud, the then Chief Justice, and Honorable Justice J.P. Parthiwala, and Honorable Justice Manoj Mishra. Let us understand how they have started, dear friends. They have given 4 tabular columns. This was authored by Honorable Chief Justice, the then Chief Justice Dr. D.V. Chandrachud. It has been classified into 4 categories. Category number A is background of the present dispute. B is submissions. C is analysis, how they are going to analyze. And D is conclusion. So C is analysis and D is conclusion. So let me take directly to analysis, dear friends. We have seen the facts and we will see their analysis. Page number 123. First analysis is under which they are referring to 4 points. Under analysis, the honorable judges dealing with 4 points. The first point is All India Judges Association case. The first point is All India Judges Association case. Number 2, the second point is the rules can be supplemented to fill in gaps. The rules can be supplemented to fill in gaps. Number 3, Sivanandan CT. It is also one of the cases. Sivanandan CT. Number 4, Articles 233, 234 and 235 of the Constitution of India. So we are going to see in detail all these 4 points based on which they have upheld the judgment of the Honorable High Court of Punjab and Haryana. Now let us see, dear friends, see analysis. First serial number is All India Judges Association. So I am going to take you only to the relevant portions due to paucity of time. So I am skipping many points, but I will not skip the main points. Para number 33, please take down. In this, the decision in All India Judges Association 3, All India Judges Association 3, citation is 2002 volume 4 SEC, page number 247. So you must remember, this is All India Judges Association within bracket 3. Rules were framed in various states to comply with the directions. Subsequently, many high courts found it difficult to fill up certain aspects like 25% post through the limited departmental competitive examination. Therefore, in All India Judges Association versus Union of India, this was in the year 2010. This court reduced the quota of judicial officers from the limited competitive examination from 25% to 10%. Now, the portion is what I am going to tell you is how the district judges are appointed, on how many ways. There are 3 ways. That is what they are going to explain now. This is the question. How judges are appointed, district judges, through 3 sources. The first source is 65% of seats. 65% of seats by promotion from the cadre of civil judges, senior division, on the basis of the principle of merit cum seniority. I repeat, 65% of seats by promotion from the cadre of civil judges, senior division, on the basis of the principle of merit cum seniority. Number 2, 10% by promotion on the basis of merit through a limited competitive examination for civil judges senior division fulfilling stipulated qualifying service. This is second way. The third way is 25% seats by direct recruitment from amongst advocates who fulfill the eligibility requirements. These are the 3 ways based on which they are appointing. I am reading para number 39 because the question is whether can they fix 50% for written examination, 50% for viva OSI independently instead of aggregate. The submission of unsuccessful officers, because they are aggrieved, they are unable to secure. What is their submissions? Let us understand. The submission of the unsuccessful officers that there is no valid basis in law to impose a minimum eligibility cutoff of obtaining 50% marks individually in the written test and the viva OSI. When such a requirement is not imposed, that 65% unsuccessful candidates in 65%, they are saying such prescription is not for 10%, is not found in 25%, why only to our 65%? That is their argument. When such a requirement is not imposed either for direct recruitment, that is 25%, they are talking about advocates, or for the limited competitive examination, that is they are talking about remaining 10%, cannot hold substance. Their submission cannot hold substance held by Supreme Court. Why? The reason is this argument is premised on the fact that there are 3 different modes of recruitment are meant for the same post. Yes, there are 3 different categories. It is argued that since the purpose of all the 3 sources is to recruit persons for the same post, a different requirement such as the 50% cutoff requirement for the viva OSI in one of the 3 modes is arbitrary. When it is not found, this condition 50% in viva OSI is not found in 10% or 25%, why it is prescribed only for our 65% category? It is arbitrary. So it is arbitrary. That means it is a violation of Article 14 according to the unsuccessful candidates. Though the recruitment is meant to fill vacancies in the same post in the higher judicial service, the candidates taking the 3 routes to reach that post are placed differently and they must be tested differently. Here the answer of the Honorable Supreme Court is, though destination is maybe same for the post of district judge, but you don't stand on the same pedestal. You come from various different sources. Therefore, you are different. Only there cannot be any discrimination among equal, but there can be a difference when there are different categories. Therefore, they are recognizing first they are different people. In service, candidates seeking recruitment through promotions cannot be considered on par with the candidates seeking direct recruitment, or for that matter with candidates seeking accelerated promotion through a limited competitive test. So the test is, first and foremost, the Honorable Supreme Court has recognized that you don't fall on the same pedestal, you come from different arena, therefore you cannot claim equality among 25 or 10%. That is the first thing. Secondly, even among the candidates seeking promotion, there is a clear distinction between those who are recruited under Rule 6(1)(a) based on, now the second distinction is, for 65% it is based on merit cum seniority, and those who are recruited under Rule 6(1)(b) based strictly on merit in order to avail of a quicker promotion. This court in All India Judges Association clearly noted that rationale for accelerated promotions was to afford an incentive to those who were relatively junior but desirous of promotion. Similarly, in Dheeraj Moore versus High Court of Delhi, a 3-judge bench of this court held that the purpose of promotion through a limited competitive examination is to ensure that in service candidates are able to take marks to hold the post of district judges on the basis of their merit. Here in this paragraph, the Honorable Supreme Court has held how they are different. 65% and how remaining 10% are different. That is accelerated promotion based only on the merit. But 65% is based not only on the merit but also on the basis of seniority. So there is a distinction. Therefore, don't say that there is no 50% aggregate in Viva. Why such requirement is not found in 10% is something different. They stand on a different pedestal. Now, the rules prescribe, I am reading para 41. The rules prescribe different criteria for assessing the in-service judicial officers eligible for promotion, while one is based on merit cum seniority, that is 65%. The other is based strictly on merit, or seniority. Seniority will not be considered, only merit. The difference justifies the distinct method of evaluation prescribed under rules 8 and 9. So further, ultimately, after distinguishing everything, bearing in mind the distinct nature of the test under rule 8, it cannot be gainsaid that there is a valid basis for imposing a distinct requirement in this case of an eligibility cutoff both in the written test and the viva voce independently. The fundamental point is that each of the 3 avenues for appointment to the higher judicial service are distinct and are based on classifications having a nexus to the object and purpose sought to be achieved. Whether such a requirement is violative of articles 233 and 235 is a separate matter which would have to be adjudicated independently, which we will do so in the subsequent part of this judgment. So ultimately, dear friends, the Honorable Supreme Court has held in the present case, the High Court has come to the conclusion, from seeking proficiency in the substantive knowledge of law and based on the written test in service judicial officers must possess communication. They are talking about the object of the interview, must possess communication and other skills which would emerge in the course of an interview. we must be mindful of the fact that the interview in such cases is not being held at the very threshold of the service while making recruitments at the junior most level. Rather, the interview is being held to fill up a senior position in the district judiciary, that of an additional district and session judge. Such officers, based on their prior experience, must be expected to demonstrate a proficiency in judicial work born from their long years of service. The purpose of the interview for officers is that, now they are talking about what is the purpose for conducting an interview. The purpose of the interview for officers is to assess the officer in terms of ability to meet the duties required for performing the role of an additional district and session judge. Consequently, there would be a reasonable and valid basis if the High Court were to do so, to impose a recruitment of a minimum eligibility or cutoff both in the written test and viva voce separately. So, in this first serial number, the answer given by the Honorable Supreme Court was this, dear friends. According to the unsuccessful candidates, they have held, you are appointing for the post of district judge, but you are prescribing only minimum criteria 50% viva voce only for 65% promotion, not for remaining 10%, not for remaining 25% also. So, it is a violation of Article 14, that is right to equality. But the Honorable Supreme Court has held, first and foremost, don't claim equality, because you are not equal. You come from, you are a distinct category. You don't compare with 10% or 25%. And second is the object. What is the object for prescribing 50% viva? The object is to select the best candidate. That is the object. So, only to analyze the performance of a candidate closely, they have kept it. Therefore, there is a rational basis, classification is reasonable, and you are a distinct people. So, therefore, intelligible differentia, there is a difference. Why there is a difference? Because reason is, what is the object is to be achieved? We need a best candidate. Therefore, classification is reasonable. So, no violation of Article 14. That is the finding of the Honorable Supreme Court. Now, next, the rules can be supplemented to fill in gaps. Here the rule says, dear friends, the rule says 65% ought to be appointed through merit cum seniority. But how do you do that? So, there is a gap. Rule does not say prescribe the minimum rules. There should be written examination, there should be a viva, nothing is stated. Therefore, the Honorable High Court on its administrative side, to fill in gaps in the rule, they have prescribed this minimum criteria. So, that is what we are going to read. According to Rule 6(1)(a), the inter se merit of the judicial officers play a greater role in making promotions. The passing of a suitability test is a measure of assessment of the merit of the judicial officers under consideration for promotion. The passing of a suitability test, in other words, is complemented by the requirement of observing the principle of merit cum seniority. I skip this paragraph, dear friends. Let me take you to the paragraph 55. In the present case, the rules are silent. This is the ultimate finding with respect to whether the rules can be supplemented to fill in gaps. In the present case, the rules are silent in regard to the manner in which the merit of suitability would be determined. In view of the silence of the rules, it is open to the High Court, in the exercise of its administrative authority, to provide the modalities in which merit or suitability would be determined. So no rule which says that there will be a minimum of 50%, nothing was there. When rule was silent, it can be, gaps can be filled by the High Court on its administrative side through passing a resolution. But such resolution cannot go against the rules. That is the condition. They cannot go against the rules, but they can be supplemental. They can act in aid of the rules. This is the second point, dear friends. The third point is referring to Sivanandan CT. Now I am going to give you the citation also. Sivanandan CT C.T versus High Court of Kerala. It is reported in 2024 volume 3 SEC page number 799. So in this case, what was the issue was, when the process, I am referring to Sivanandan case, what was the issue there? When the process of selection had commenced, all candidates were put on notice. One of the conditions was no cutoff was applicable in respect of the marks to be obtained in the Viva OC while drawing up the merit list in the aggregate. So what they are saying is, at the time of selection, there was a specific rule by saying no cutoff will be taken into consideration. So based on that, selection started. Candidates participated. Now while drawing up the merit list, they introduce cutoff. After the conduct of a Viva OC, the High Court decided to apply a minimum cutoff in the Viva OC as a qualifying criterion. So which is bad, which cannot be done. Based on this, in Sivanandan case, they invoked doctrine of legitimate expectation. So same doctrine has to be applied here. That was the submission made by the unsuccessful candidates. And in this case, they have said, para number 61, dear friends, the unsuccessful candidates in the present case have further relied on Sivanandan to contend that the absence of notice to the candidates about the imposition of the minimum cutoff marks for the Viva OC contravenes their legitimate expectation. In Sivanandan CT, this court held that an individual who claim a benefit or entitlement based on the doctrine of legitimate expectation has to establish two conditions. Now, a note of caution, dear friends. In the advocate on record examination, one of the questions might be asked like, explain the principles of legitimate expectation. Legitimate expectation doctrine, please explain. For that, answer is given. Let us understand. So, court held that an individual who claims a benefit or entitlement based on the doctrine of legitimate expectation has to establish, number one, the legitimacy of the expectation. Number one is legitimacy of the expectation. That expectation must born out of legitimacy. Number two, that the denial of the legitimate expectation led to a violation of Article 14. Then only you can invoke doctrine. Assuming that, for example, let us test Sivanandan case. In Sivanandan case, before the selection, they have said no cutoff. But after Viva was over, cutoff was introduced. So according to the candidate who could not come to the cutoff prescribed for Viva, they are aggrieved. They will say, when we were taking participation at the time of selection, when it was intimated that no cutoff will be there, so we had an expectation. Expectation based on the notification given by the High Court of Kerala itself. So there is a legitimacy to the expectation. And now introducing cutoff, it is violating our Article 14 because it is arbitrary. Because it is arbitrary. So the legitimacy to the decision which led to the violation of Article 14. So therefore in Sivanandan case is something different. But here, whether does it apply to this present Kavita case, Dr. Kavita's case, let us see. In Sivanandan CT, the statutory rules coupled with the scheme of the High Court generated a legitimate expectation that the merit list would be drawn based on the aggregate of the total marks received in the written examination and Viva Voce. There would be no minimum cutoff marks for the Viva Voce. This was their expectation. But however, now they are, whether they are distinguishing, the Honorable Supreme Court is distinguishing Sivanandan case, how it is not applicable to our present case. How this doctrine of legitimate expectation is not applicable here. In the present case, neither the statutory rules nor the High Court committed that there would be no cutoff marks for the Viva Voce so as to give rise to such a legitimate expectation on behalf of the petitioners. Furthermore, the decision of the High Court to apply the minimum cutoff marks for the Viva Voce is grounded in legality, therefore cannot be faulted for contravening the established practice. So they have not changed the rules. So therefore legitimate expectation is not applicable in this case. Now the fourth serial number, dear friends. In the analysis is the fourth point. Articles 233, 234 and 235 of the Constitution of India. That is the heading. That leads us, this is how they begin, the Honorable Supreme Court at para 62. That leads us to the analysis of the provisions of Articles 233, 234 and 235 of the Constitution. Clause 1 of Article 233 stipulates what? Appointment of persons to the district judges in the state, that is in the state of Punjab and Haryana in this case. Their posting and promotion shall be made by the governor in consultation with the High Court exercising jurisdiction in the state. This is what Article 233 clause 1 says. So, to the post of district judges, they have to be appointed by the governor of the state in consultation with the High Court, concerned High Court. According to Article 234, appointments of persons other than district judges to the judicial service of a state are to be made by the governor in accordance with the rules made in their behalf after consulting the State Public Service Commission and the High Court exercising jurisdictions in relation to the state. Now the important aspect is in Chandramohan, para number 65, Chandramohan versus State of Uttar Pradesh. It is also a constitution bench judgment. A constitution bench of this court, speaking through Chief Justice K. Subbarao, held that constitutional mandate under Article 233 is that exercise of the power. Now they are discussing about how governor is appointing and how governor is going to consult with the concerned High Court, and what is the importance of that consultation, whether it is recommendatory in nature or mandatory in nature. Everything is discussed. Now role of High Court in appointing the district judges, that is what we are going to see in these paragraphs. The object of consultation is that High Court is expected to know better than the governor the suitability of a person belonging either to the judicial service or to the bar for appointment as a district judge. The court held that mandate would stand disobeyed if the governor either did not consult the High Court at all, or if it were to consult the High Court or any other person in the manner not contemplated. If a High Court is not consulted, that means governor is acting against the constitutional scheme. Or if the governor is seeking the consultation of some other body other than the High Court, that is also against the constitutional scheme. The ultimate authority is the High Court. High Court has to be consulted because High Court is the expert body where they know better they know better performance of the individuals, of the judges than the governor. The court held that in case the governor consults an authority other than the High Court, it would amount to indirect infringement of the mandate of the Constitution. In situations where the Constitution sought to provide for more than one consultant, it did so. Impliedly, this court held that duty of consultation is intertwined with the exercise of power itself, and such power can be exercised only in consultation with the person or persons designated under the relevant provisions of the Constitution. Further, dear friends, in para 67, State of Haryana versus Inder Prakash Anand. This is yet another case. A constitution bench of this court, speaking through Chief Justice A. N. Ray, observed that High Court is acquainted with the capacity of work of the members already in service. Underlining the significance of the High Court's control over the appointments under Article 235, it was held High Court's opinion, this is very important, High Court's opinion will have a binding effect on the governor according to the constitutional scheme. So, it is not only a consultation. Once it is consulted, High Court is consulted, once these 13 candidates were recommended, they have to be appointed. It has a binding effect on the governor. And then, in numerous decisions, I am reading para 70, dear friends. After discussing everything, let me read one more paragraph also, beautifully explained. The court observed in Bal Mukund Saw, it is one of the cases, it is now time for us to take stock of the situation in the light of the constitutional scheme guaranteeing independence of the judiciary and separation of powers between the executive and the judiciary. The constitution makers have taken care to see by enacting relevant provisions for the recruitment of eligible persons to discharge judicial functions from the grassroots level of the judiciary up to the apex level of the district judiciary. The rules made by the governor in consultation with the High Court in case of recruitment at grassroots level and the recommendation of the High Court for appointments at the apex level of the district judiciary under Article 233 remain in sole repository of power to effect such recruitments and appointments. For judicial appointments, the real and efficacious advice contemplated to be given to the governor while framing rules under Article 234 or for making appointments on the recommendations of the High Court under Article 233 emanates only from the High Court, which forms the bedrock and the very soul of these exercises. So ultimately, while appointing the district judges, the recommendation given by the Honorable High Court is the bedrock and the soul of these exercises. It is axiomatic that the High Court, which is the real expert body in the field in which it vests the control over the subordinate judiciary, has a pivotal role to play in the recruitment of judicial officers whose working has to be thereafter controlled by it under Article 235 once they join the judicial service after undergoing filtering process at the relevant entry points. It is easy to visualize that when control over the district judiciary under Article 235 is solely vested in the High Court, then the High Court must have to say as to what type of material should be made available to it both at the grassroots level of the district judiciary as well as the apex level thereof, as to effectively ensure the dispensation of justice through such agencies with the ultimate object of securing. Why there is a specific prescription of 50% viva? The reason is the ultimate object of securing efficient administration of justice for the suffering litigating humanity. That is the purpose. If you have a good judge, he will appreciate all the issues of a litigant and he will render justice. So to have effective justice, we should have an effective judge. To have an effective judgment, as a role of a lawyer, we have to give effective assistance. So under these circumstances, it is impossible to countenance bypassing of the High Court. You cannot bypass the High Court either at the level of appointment at the grassroots level or at the apex level of the district judiciary. The rules framed by the governor as per Article 234, after following due procedure, and the appointments to be made by him under Article 233 by way of direct recruitment to the district judiciary solely on the basis of the recommendation of the High Court clearly project a complete and insulated scheme of recruitment to the subordinate judiciary. This completely insulated scheme, as envisaged by the founders of the Constitution, cannot be tinkered with by any outside agency, dehours the permissible exercise envisaged by the twin articles, Article 233 and 234. Finally, at para 71, we are in agreement with the High Court that the state government travel beyond the remit of the consultation with the High Court by referring the matter to the union government. Any issues between the High Court and the state government should have been ironed out in the course of the consultative process within the two entities. The state government was bound to consult only the High Court in the manner elaborated by the aforementioned judgments. Any other exercise, dehours such consultation would not be in accordance with the scheme of the Constitution. This is para 17. Let me read 71 also, dear friends. In numerous decisions, this court has emphasized the importance of the control which is wielded by the High Courts over the district judiciary. Undoubtedly, it is equally well settled that when the rules under Article 309 hold the field, these rules have to be implemented. Where the specific provisions are made in the rules framed under Article 309, it would not be open to the High Court to issue administrative directions either in the form of full court resolution or otherwise that are inconsistent with the mandate of the rules. On the other hand, in case such as the one at hand where the rules were silent, it is open to the High Court to issue a full court resolution. The High Court did so initially in the year 2013 but modified the resolution on 30th November 2021 by prescribing that the candidates for appointment to the higher judicial service should have minimum of 50% both in the written test as well as in the viva voce independently. The wisdom of the prescription is clear. A candidate should not just demonstrate the ability to reproduce their knowledge by answering questions in the suitability test, but must also demonstrate both practical knowledge and the application of the substantive law. In the interview, they will test the presence of your mind and how do you apply law to the given facts. So application of the substantive law in the course of the interview. The rules being silent, it was clearly open. This is important. The rules being silent, it was clearly open to the High Court to prescribe such a criteria as it did in 2013 when the 50% cutoff was prescribed on aggregate scores, and also in 2021 when the 50% cutoff was prescribed on the written test scores and the viva voce separately. So ultimately the Honorable Supreme Court has held that 50% independently for written examination, 50% aggregate in viva voce independently, it is correct, it is valid because they need efficient administration of justice. Conclusion. We have therefore come to the conclusion that the state government was plainly in error in finding fault with the process which is being followed by the High Court, and in concluding that the decision of the High Court amounted to an arbitrary exercise of the power, though the Solicitor General pointed out that the expressions arbitrary and betrayal of trust were used in the communication of the state government, placing reliance on earlier judgments of this court, we would leave the matter at that while affirming the conclusion of the High Court. Para 73, this is a concluding para. For the above reasons, we hold that the impugned judgment and order of the High Court dated 20th December 2023, that is High Court order, does not suffer from any legal or infirmity. The appeals shall accordingly stand dismissed, pending applications, if any, stand disposed of. So therefore, dear friends, ultimately they have said we need a efficient administration of justice. Therefore, we have prescribed, the High Court has prescribed minimum 50% individually, both in written as well as in viva voce. This is for good for the system, and the state government is bound by the recommendation made by the High Court. Therefore, anything which goes against the High Court recommendation becomes against the constitution scheme. So ultimately they have held that 13 people who are about to appoint for the post of district judge, that is valid. So thank you so much for your patience hearing, dear friends. Thank you so much. Now we will take few questions and then, yes sir.
So number one, since this is a civil appeal, correct? Now, when a civil appeal moves to High Court, you have LPA. Generally, you have LPA, right? Letter patent. So my first question is that when the so 39 candidate, right, went to the High Court and High Court said that no, these 13s are going to be the district, then I'm sure that they must have invoked the power of the LPA also. Right. So I guess that the LPA must upheld what the single judges said. I guess, because without moving to LPA, you cannot file SLP 136. Point number one. That I will see. And but what is the basic point? My second question. This is first question. This LPA is there or not? Right. Because point is that we have to go to LPA. Right. The second question is very important, which the problem as the lawyers which we are facing most of the time, and trust that all my engineers are more intelligent than me, that generally Supreme Court, when to pronounce a judgment, Supreme Court pronounce a judgment on a fact, and Honorable Lordship Nagaratna ma'am said a very good thing, that it is a fact which decides the law, not the law which decides the fact. So ultimately, we first need to understand the fact, and then we'll see whether law fit into or not. How can we simply go to a judgment and say, "Bhai, aisa tha to aisa tha." Now the question here is that, as a lawyer, what problem we are facing when Supreme Court pass a judgment, Supreme Court pass a judgment on a fact, and many a times we face a very challenging situation in the court, that a party coming and saying that this judgment is now per incuriam in nature, or a part of the judgment is per incuriam in nature. Example, I hope everyone knows us. Why I am raising this point in this?
Yes, yes, that is
there is a practical problem which is going to start from Monday, as far as this judgment is concerned. Now, in Muhammad Arif, I hope you remember the Lal Killa incident, Lal Killa firing incident, when one of the terrorists was caught by Delhi police. Then the point of question was Section 65B certificate.
See, anything related to this case,
yes,
then
yes. But coming to it.
Yes.
So whether any part is per incuriam or not, that is something which I need to check. Because from Monday, if it is not per incuriam in nature, then why Supreme Court is going to be citing a constitution bench coming week, constitution bench, to once again decide the rules and regulations regarding the appointment of the district magistrates. If this judgment is not per incuriam, or any of the facts is not made per incuriam by Honorable Supreme Court going forward, after 2024, then why Honorable Chief Justice Sir is setting up once again a constitution bench to decide something which has already been decided?
Let me answer, sir. First and foremost is the, irrespective of sir's question, the purpose of this academy is to focus on AOR examination. So in the AOR examination, they will ask what is the doctrines involved, what is the principles involved. So first question what sir has asked is whether there was any single judge bench judgment, thereafter was there any LPA, or thereafter did they prefer SLP, or what, right? This was the question. That is the procedural aspects, and we cannot concentrate on many aspects with respect to the procedure. We concentrate only on issues and findings what is relevant for the AOR examination. But to my knowledge, it must have come before, because we cannot speak on hypothesis. So we have to check, right? So with respect to LPA is concerned. And secondly, Article 136 is an extraordinary applied jurisdiction. It goes by saying any order, any judgment, any determination, any sentence passed by any court or tribunal in the territory of India can be preferred to the Supreme Court directly, except the sentence or orders passed by the Armed Forces Tribunal. So Article 136 is such an extraordinary applied jurisdiction. Even from a single judge passed by the High Court also can be challenged under 136. Even if it is passed by the District Court also, that can be challenged under 136, provided we satisfy the conscience of the Supreme Court by saying why we did not approach the High Court. So Article 136 cannot be confined within the four walls. So it is such an extraordinary appellate jurisdiction vested with the Supreme Court. Yes, with respect to this per inquirium and everything, I will leave it to the wisdom of the honorable judges to decide. So I don't want to make a comment as of now on that issue, sir. So thank you so much. Now we have reached yet another. Yes, you can disconnect, ma.